Hello, YouTube. It is me, Vince White, and I am an employment attorney. Still, to this day, an employment attorney. And I am answering publicly posted questions on YouTube. This question was posted by YouTube user Jay Hefner, and it was posted on our video from August 24th of 2022, entitled, "I'm not sure I can trust my employment attorney. Should I share my evidence with she or he?" And Jay Hefner asked, after filing a lawsuit on a contingency contract, the attorney began to fall back from the case, even admitting to a lack of work ethic. How will the contingency transfer if a plaintiff decides to switch counsel? Got it. Okay, so there's three basic situations where plaintiffs try to switch counsel. I guess four. The first and the easiest to deal with is like a mutual parting of ways. The attorney no longer wants to represent the plaintiff, and the plaintiff no longer wants to be represented by the attorney, and they mutually agree to part ways. That usually will mean they have a settlement in place for how the contingency would transfer the lien that the attorney has in the case, or they've taken care of the lien, or the attorney is just dropping the lien because they have a deal in place. They have agreed to not go forward together. Now, the second scenario is like a comic relief scenario. This is always really funny. This happens more often than you would believe. You'll be at mediation. You'll get defense counsel to come to the number that your client wants. Defense counsel will come to the table and will announce, "Fine, we're coming to 11 billion." And your client, who you've supported, who you've been the wind beneath his or her wings for months or years, who you have spent tens of thousands of dollars helping and thousands of hours representing, will look at you and say, "Oh my God, that's amazing news. Thank you so much. You're fired." And then they'll immediately turn to defense counsel and say, "I accept." Because in all their wisdom, that human being thought that they, of all the tens and hundreds of thousands of plaintiffs that have come before them, they themselves, that particular individual, was the first to figure out that super special loophole wherein, oh, I won't pay my attorney's contingency if I just fire my attorney before I collect. Never mind that the entire industry could not exist if that was true. Never mind that all the judges and all the lawyers, all the arbitrators, and all the plaintiffs before you didn't think that would work and plan for that. And that's part of everyone's thinking, that that can't be the case because none of this could work if it was the case. Never mind all that. There will be plaintiffs who think that. And then when it ultimately doesn't work, because that's not how any of this works, they'll do wild things like grieve attorneys and like issue death threats and spit on you, and just the loveliest of behavior after calling you Saturday night for years, being like, "I'm just so sad, they did so much to me, and then trying to screw you out of all the money and time you spent helping them, right? So that's always a hilarious scenario. I only add as comic relief. I know, Jay Hefner, that's nothing like what you're doing here. What you're doing here is more like the third scenario, which is the attorney is not living up to the contract. And in most jurisdictions, what this is going to be called is a for-cause termination of representation. Basically, what's happening here is the plaintiff is saying, "Hey, attorney, you're doing a bad job. You're not doing what you should be doing, in very basic ways. And I don't mean like a small thing, like they wanted you to ask an extra 7 questions in deposition. That's not what we're talking about. It's like you're not litigating this case in a responsible manner. You're blowing statute of limitations. You're being abusive towards me. You're lying to me. You're misleading me. You're trying to force me to settle my case when I don't want to. Like there's many ways to have a for-cause termination of representation. And I think, Jay Hefner, that's what you're looking at here. Now, in most retainer agreements that I've seen, and I believe in most jurisdictions, but you need to check your local jurisdiction, a for-cause termination of representation can lead to an extinguishing of the lien of the attorney, right? Now, you have a very legitimate gripe with this person because you're like, hey, you're not litigating the case is not moving, and you're telling me you lack work ethic. That sounds like that attorney would probably just be willing to let that case go because there's something wrong with that attorney. That attorney sounds like maybe they're dealing with depression or battling like addiction. I don't know. I don't know who that person is. I don't know anything about that person. I'm just saying, sounds like an attorney in a bad place. I bet they might just be like, hey, I would agree to let your case go and give up my lien. So that might be a conversation you could have before you even have to fight it out in a fee dispute or grievance or whatever it is with your attorney over whether or not that termination was for cause. Now, this also leads to kind of a subclass of fights over representation where clients will try to like fake up pretext to fire an attorney. Like, do you remember on September 1st of 1983, I asked you to ask X, Y, and Z, and you told me those weren't questions you could ask. And I think they could have been asked, and you don't care what I think, and so I'm firing you for cause. No. That's not going to work, right? Like I think pretty much any attorney's going to be like, yeah, okay. I mean, that's not for cause, and that's not going to be for cause, and you're being silly. And it's really easy to deal with this. We're just going to put the money in escrow, and if you want, we'll go to a fee dispute provided by the Bar Association, which is a great program in New York State, or we can deal with an arbitrator, or you can sue me, like however you want to figure it out. But we're going to have to go to a third party as required by the laws of whatever jurisdiction we're in that can decide this, because we're not going to agree. You're saying you're firing me for cause because you want all your money. And I'm saying you're being a silly little hobbit, and I'm not going to do that, right? So that's a very simple solution too, right? That subclass where it's like a fake claim of for-cause termination it's very simply dealt with. Like, it's not a serious problem in our industry because judges and arbitrators and fee dispute committees and grievance boards all exist to deal with those things. And they are intelligent human beings who know a lot about litigation, who will sit and listen to the evidence, and the attorneys will present their side and the client will present their side, and they'll make a decision, and 99 times out of 100, the attorney is going to be very happy with that decision if they've done nothing wrong, right? So this subclass, like for cause but on a pretext, silly, right? The last group, and again, this one does not apply to you, and the pretext obviously does not apply to you, Jay Hefner. You have a very legitimate gripe here. The last group, or last kind, I guess, category of parting ways of plaintiff and attorney is often paranoia based. And I've heard this a couple times. I think you're taking bribes. I think you're working against me. My man, you make $12 an hour. Or, I mean, $15 an hour now. Like, nobody has time to bribe anybody about you. Like, we want to help you, and they don't want to pay you. But that's pretty much the extent of it. Like, there's no spy games. We're not running KGB psyops over your case with, minimum wage economic damages. It's just not realistic. It's not, you don't have a $30 million case. Nobody's ending up dead in a dumpster because Steve is a bad guy at work, right? Like, it's just not really realistic. But you do see this. People call me like, oh, my attorney is on the take. He is taking bribes. I know it. And I'm like, oh my God, how do you know it? Well, they consented to an adjournment of 2 weeks. Yeah, because the judge was going to give it to the other side anyways. Like, what? Yeah, if he didn't do that, the judge would have reamed him out and it would have been bad for you. And what is 2 weeks? Like, it's just a ridiculous thing, right? And those paranoia ones are generally not going to be viewed as for cause terminations either, because there's no way to. Like, there's almost certainly no teeth to that. I do know, like, there are scandals in our industry. I've made videos about them where attorneys have actually had like fee fixing or bribery scandals, and they're incredibly rare and also incredibly huge. Like, huge sums of money are in play when those things go down, and they're very complex, but they're not generally going to be on individual employment matters because no one's license is worth like a $10,000 bribe or even a $100,000 bribe. Like, it wouldn't make sense. Like, if you put it in context, like, somebody came to me and they were like, I will give you $500,000 to take a dive on this case. My license is worth a lot more than that. And the risk on that's pretty high. So even if I was a monster, and even if I didn't care about my clients, I still wouldn't do that because I'd have to be stupid to do that. Because there's a very high chance I would lose my license, and maybe worse. And if I lose my license, I lose my livelihood, which is, frankly, worth a great deal more than that bribe over the course of my career. Exponentially more. Almost everything good in my life comes from having my license and helping people. So, like, the bribery thing or the paranoia, rarely true. Rarely true. So anyways, Jay Hefner, I hope this answered your questions. Your question. And if it didn't, or if you have more specificity, you want to ask with a little extra detail, let me know. I'll check the comments down below and I will try to provide you additional answers. And if this was helpful, like and subscribe. It helps me to help more people just like you.